Okay, 3:30, I'm gonna call this meeting of the select board to order at 3:30 on Wednesday, August 17th. Are there any adjustments to the agenda? Terry, do you have anything?
No.
No? Good to go?
Good to go.
Sue, Jeff?
No.
Okay. No do it. New business, discussion with town attorney and code enforcement officer regarding code enforcement. This was gonna be the sole and exclusive purpose of this meeting, but we have since added two agenda items. So I don't know how, in what order we want to take these up. I think the bulk of our time, I'm hoping we can devote to item A. But I guess I'm open to thoughts from Jeff or Sue or Kristen, or what is the best way to do it. And just while we're at it, I understand you two are trying to meet after, or.
I thought it was at this meeting, I didn't know.
No.
She called me, texted me a while back, asked me to meet it today.
Yeah, but it wasn't part of this meeting. I was under the impression you two were meeting private.
Yeah, I think I said before or after.
Okay, so you don't need
So-
to hear now?
Well, no, I mean, you're welcome to stay for certainly the open sessions. But I think, obviously, I just trying to figure out who's meeting when with what, that's all.
Would it be more convenient for you to meet a little bit before tomorrow's meeting? Rather than.
Depends what it's about,
This
because I
one.
gotta kinda know. I gotta know before, I gotta.
Just going over the issues in the application and procedure for the
I'd
meeting.
rather do it today sometime.
Okay, so you got time to hang around, and
Well,
it's gonna be a while.
Couple hours.
Yeah, I'll take it.
just give me a call, 5 minutes from here.
Okay,
I think, because I wasn't planning on it, I have commitment at home a little bit later, so if you could do tomorrow, that would be a lot better for me. I can figure it out, but.
can you guys do a Zoom meeting?
Wait, you can call me.
Call.
Call me. What you
Okay.
wanna do?
Is there a time tomorrow that's better?
I don't know. Okay. I'm up all day. I get in the morning.
I'll give you a call when I get a minute tomorrow. And we'll
Okay.
go
Is there
over it.
any questions coming up right away that you might need me here for? Or?
I don't think so tonight.
We're talking
We're
enforcement
talking
tonight,
enforcement.
unrelated to
but-
planning board.
And we're talking a training session, which is the bulk of our discussion. And you're certainly welcome to sit through that if you would like to.
Well, I don't think it's sick to say about enforcement from that.
Okay, well, whatever. Okay, so why don't we follow the agenda? And we'll start with the workshop, if you will. I did put together a sort of an outline of what I thought were kind of the critical points that we should
Make sure I was gonna call you back.
cover. And I'm hoping this is beneficial for Sue and Dan, but also as a refresher for Jeff and I. And as I said in my email, we can throw this in the trash, or we can walk down through this, and I'm happy to kind of lead that, and we can ad lib as we go. Is that acceptable to folks?
Yeah, there's some of this that's not really that relevant to South Thompson. Maybe we'll skip through, but
Yeah, but I just wanted to kind of set the background, and I don't have a good sense of what you do and don't know, and so if we're following stuff that is too simple, just tell me and we can move right through it. So, good. So I just started out with a list of our ordinances that involve the code enforcement officer, which includes the shoreline zoning ordinance, which was last amended June 21, and includes a map, of course. Land use ordinance, which is really what I think is the major focus. The floodplain management ordinance, which if you recall, we sort of got in trouble once before with the state because it wasn't being enforced and we weren't issuing permits, and we were being threatened with suspension, which means everybody in town gets suspended if we don't follow that ordinance. So I just wanted to make sure you're on top of that, and we know there's updated maps that came out fairly recently, which I understand you have, or Terry knows where they are. we can revisit that a little, later on, but I think the critical thing there is if we get suspended from that, everybody in town loses their flood insurance, federal flood insurance, so,
Talk to Owl's Head right now.
oh, is that right?
Yeah,
Oh,
they're getting threatened with it.
well, and we kind of got let off the hook once before, and so I'm not sure they're gonna let us off the hook a second time, so. Then we have the new storage of solid waste and junk, which I know you have some questions about when we get there on enforcement. The CEO is also responsible for enforcing the town landing ordinance. I don't know if you're aware of that or not, but you are.
I got heard something about that.
And then, of course, we have the subdivision regulations that is mainly a planning board thing, and it's technically not an ordinance, but those are the only land use documents or ordinances, for lack of a better word, that I can think of locally. Do you?
Just the planning board ordinance.
Yes, right. And that does outline some CEO. Yeah. The ordinance that created the planning board and has been amended. Thank you. And then I listed a bunch of the state statutes and where they are, which was just for reference purpose, the mandatory shoreline zoning law, which is where the federal flood insurance program is included at section 444. I'm not going to go through all of these, but there is that new law, which I label as LD 203, which addresses housing shortage, and it's pretty complicated, and I don't think we've done anything on that yet in terms of amending our ordinances, or if we have to or not, but and we do have an ordinance committee, which Jeff is the chair. So,
Well, right now, I'm still taking her at her word that it's not going to affect us at all.
her being our representative from the legislature, yeah, to the legislature. But anyways, I think that's something we need to keep an eye on. It's brand new. And then I just sort of listed some resources that are available, obviously, to the CEO, the town administrator, select board, planning board, other local CEOs, and the town attorney. I've encouraged Dan that anytime he feels he's getting over his head in something, to give Kristen a call. And she can help you, and I hope you will do that. And I think it's better to spend a little money in prevention than get embroiled in a lawsuit. And then I listed some other resources at the state, the DEP, shoreline zoning staff. I think Colin Clark is still our rep for this area. Pardon?
Yeah.
Yeah. Sue Baker is at the flood insurance program. State plumbing staff, I'm not aware of who they are. I think you are there though, so you're in pretty good shape there. Then of course we have MMA legal, all the MMA manuals that are online, and I don't know if people can think of others, but and then so anybody jump in here with additional information or comments anytime. Then CEO LPI roles. I saw the major ones as the staff assistant to the planning board, which I think you and Irv are working out fine. Obviously, processing permits, applications, and following the timelines and the forms. And I do have a couple of comments on our form when we get to a deeper discussion. And then I just listed some of the key things that a permit application, as I see it, can go either return for completion with it, and I think it's important that the CEO document that and with dates, referred to the planning board if that's required by the table of use, and then either deny or issue the permit if it's a CEO permit. I don't know if anybody can think of another avenue or permit if application could go, but
Approval with conditions.
well, yeah, okay, I put restrictions on there, but yeah, conditions, yeah. And then enforcement procedures. I think the land use, floodplain, plumbing, septic waste junk and town landing. And I'd like to spend a little bit of time on this, and maybe kind of, I know you had some questions that you want to talk with Kristen about. So Kristen, could you kind of walk us through typical enforcement action? And I know they're different depending on what the ordinance specifies,
Right.
but
Yeah, that's what I was thinking, you know, we reference these various ordinances and maybe it makes sense to take the enforcement action procedure piece and just apply it to these different scenarios because they're a little different.
yeah, that's what I'm thinking. And I know in particular, Dan has a question about this new ordinance that we just enacted, which is a little different, I think, than what's in our, I think the shoreline zoning and the land use is pretty similar, but I could be wrong, but I'll let you speak.
So in terms of the procedure, the difference between the shoreline zoning and the land use is that sometimes DEP is involved in the shoreline zoning. So let's walk through a scenario where you get a complaint that somebody's cut a lot of trees. You go out there and it turns out they haven't just cut trees. It looks like they've moved material around. They've got some sort of drainage going on, you know, the whole thing looks a mess. I may have one of these cases right now on behalf of the property owner. So there's, you know, lots of stuff going on. It might be Natural Resources Protection Act violation stuff that the state enforces. It might be, you know, the cutting of trees within the setback, which the town enforces. So my preference when you get something like that, that's just kind of a mess, is call DEP, have Colin Clark come down and look at it with you when you're on site. If it's something where they may have gotten a NERPA permit already, but you think they might be violating that permit, you would want Nate Durant at the state. He's the sort of enforcement arm related to NERPA.
Can you, for all our benefits, NERPA is?
No,
I know what it
Natural
is, but-
Resources Protection Act. Yep. And so for your benefit, there are certain things that need NERPA permitting in the shoreline zone. That would be certain activities, what they call adjacent to a resource. So you're moving earth right next to the high water mark. You're trying to do anything past the high water mark. You're cutting trees within a certain setback. So things like that, any sort of drainage, discharge into the water, stuff like that.
But those are not permits we issue.
Those are not permits we issue. The state does, and you might hear this term permit by rule. That's like the shortcut process to get a NERPA permit for something that's not super involved. Even a dock, permanent dock would need NERPA permit. So the reason that we involve DEP in this stuff is because not only do they oversee our enforcement of shoreline zoning, but they also may have their own enforcement issues that they pick up too. So if they and you find that it's just a violation of our ordinance, we can deal with it, you know, going forward in one of two paths, which is we either bring an enforcement action or we negotiate a consent agreement. We do a lot of consent agreements in shoreline zoning, and it makes sense that we do because those people usually have the resources to fix whatever they've harmed. So I'd like to get DEP blessing on anything that we're doing when it's a real significant shoreline zoning violation so that they don't come back at us later, kind of like the floodplain thing and say, you're not doing your job to properly enforce the ordinance. You let this building, for instance, stay within the setback and you shouldn't have done that. Every once in a while, DEP will concede to allow something to stay, but I don't like to allow anything to stay unless they've explicitly told us that it can. So involve them in the inspection, work with me from the very start with shoreline stuff, just because it can get really complicated. So that's the only difference with shoreline zoning, but you're gonna get a complaint. If you get a complaint that is verbal, try to document it. Yes, I would write down the complainant's name. There's nothing that says you can't do that. Even if somebody says, hey, you know, this is so-and-so, but I don't want you to tell anybody that I'm making the complaint. You're completely allowed to write that down.
Is he obligated to
Not
tell,
obligated,
to
but
tell the property owner who the complaint is?
no, well, if it's written in a record and that person requests the record, then yes.
Yeah.
You know, so you can use your discretion. The problem is really when you get an anonymous complaint and then somebody later alleges that you did something wrong or you're making stuff up, it's more helpful to know where the complaint came from. So I like to have some sort of process where you at least have some record keeping system. Complaint came in on this day regarding this property and this person, here's what I did to follow up. That way there's never a question later on about what you did. So you go make your inspection. Rules about making inspections. If it is something that is visible from the road, no problem in going by, taking photos. If it's, let's say it's a 30-acre lot and there's a dooryard kind of area and house. If there's 30 acres of woods around that house, you're actually allowed to go poke around in those woods in theory without telling the property owner first. I always ask permission first, even in that situation. Sometimes you don't get it. And then in consultation with me, I might say, go ahead and, you can poke around in the woods and take a look to see if there are 40 junked cars back there. So you'll contact the property owner. You don't have to do it in writing. You can call. Whenever you do things verbally, try to make a note in your file. Called them on this day. They said, yes, come on this other day. Call, you can stop by. You can send an email if you know those details. You can write a letter. You can always post something on the property, a letter saying, I want to make an inspection, or I will be making an inspection on this date. Inform me if that's not okay. So you get your permission, you show up on the allotted day, you document your findings however you need to. And if they don't allow you in, either you get there and they're like, no, you're not coming on my property, or they tell you straight up front, no, you're not allowed to come. We have a process where we can get an administrative inspection warrant, where basically you go to a judge, it's like a search warrant. You say, I have probable cause to believe there are 30 junked cars in the woods for this reason. Guy won't let me on the property, and I want the court's blessing to be able to do it on this date. That actually requires you or I to go sit at the courthouse until a judge is ready, explain what the reasons are, and then get the warrant signed off. So you get to play cop for a day. So that's that. They are almost always granted as long as we explain why we need it. And we also have to show that we make a good faith effort to get the permission up front. So inspection, we find violations, we do a notice of violation. So under the shoreline zoning ordinance, it's actually written right in there that you have to take that step of issuing a notice of violation. Can't remember if it's in the land use ordinance the same way.
I have it, if you want it.
Yeah,
I'll find the section while you're. So back in the uphill.
yeah,
I actually had a phone call yesterday, somebody who just bought a chunk of land. And supposedly they pulled a permit for cutting some trees, but they clear cut everything, and this is on shoreline.
Yep.
And we have no permit for anything like that. I don't believe anything's been happened with the state either.
okay. You call the state to verify?
I have.
Okay.
So,
Yeah, give a call over there, talk to whoever you can find in NERPA and see if you can find a permit for them.
Sure.
Because, if is it cutting right up close to the water or is it back?
Yeah, I believe it. I haven't seen it myself from listening to the new homeowner.
Okay. Yeah, I call the state, but then I'd go through the process I just outlined.
Yeah.
Go down there, take a look, take photos. Photos are super important. If they have any plans that, you already have at the town office because they applied for some permits before, bringing the plan so you can compare it, coming back, if it's really a complex thing, we're going to try to make a written report of what you found during your inspection. Or you can just use the notice of violation as sort of your written report. So the notice of violation is going to detail exactly what you saw on the property and the whole gamut of what we think it violates. So state law, local law. We send the notice of violation out in whatever way is best, gauge to reach the person. So, I'm a big fan of stopping by if the person lives there. and then keeping your copy, making a note of when you hand delivered it. And, email is fine, if you know the person's email address. Letters are obviously great. The problem with letters, of course, is people say they didn't get them.
Sure.
So if at all possible, if it's not like a hostile situation, stop by, knock on the door, leave the notice, and also mail it.
Okay.
Does it say no violation?
Yeah,
Yep.
it's right in that section, and then it also actually quickly refers to the select board, which I'm a little surprised at, but. Could I just make one comment though? I just want to make it clear that it doesn't, the violation doesn't have to be done strictly pursuant to a complaint. The
Oh,
code
no.
enforcement officer certainly can, if he drives by and sees something, he can do it on his own volition, and should do it on his own volition, in my
Absolutely,
opinion.
absolutely.
Particularly if it's an egregious violation, so. Well, I think that a lot of people have the impression that, well, I gotta have a complaint in order to act, and that's not the case.
Yeah, actually, the piece about the selectmen in here is pretty standard.
But it does require notice of violation from the.
It
code
does
officer,
require,
correct?
yep. I shall notify in writing the person responsible, indicating the nature of violations and specifying the action necessary to correct it. So we're gonna have a specific date in the notice of violation that says when they have to correct what they're gonna correct. We're gonna be reasonable, given whatever they really have to do. Give them a reasonable time period to comply. After that, if they don't comply, you're gonna try to go back and re-inspect on that date if it's not obvious. And then what I would normally say is we take it back to the select board, give them an update. I sent this notice of violation for this property. They didn't comply by the deadline. What do we want to do next? And based on the severity of the situation, we can do one of several things. We may send another last chance notice. We might have me send that notice. Okay, well, now the lawyer's involved, this is serious. We can just take them straight to court at that point. So usually we give some sort of a last chance.
To be clear, we're still talking here about land use ordinance violation.
Land use shoreline
not-
zoning.
Not, and shoreline,
Yep.
but not the junkyard or the, okay.
Correct.
Yes.
Yep, and so, the select board's always going to be the threshold that decides whether we're going to court or not, and when. Okay. So that's where the select board is referenced in the ordinances that they were just talking about. The code enforcement officer, upon consultation with the select board, may institute land use enforcement action. So executive session, I may be involved, I may not. You get your authority to bring an enforcement action. Okay, now, are you certified?
No, I'm not.
Okay. So were you certified, you'd be able to bring an action in court yourself? Almost no one does. I wouldn't advise it. And not just to get myself more work, it's just, it's hard enough for me to get into court on these things these days, much less for someone else to try to navigate it. And these guys, the violators always get up and have some ridiculous explanation, and you have to, think on your feet. And at the very least, having somebody that will help you through it is
Sure.
really helpful for it. So an enforcement action is brought through what's called a Rule 80K complaint, which sets out exactly what the person did wrong. We usually try to provide a little bit of evidence, some photos, something like that, right, with the complaint. We provide the ordinance so that the judge can see what's been violated. And forgive me, I don't even know, were you a code enforcement officer before you were?
No.
Yeah, you weren't, okay. So you've never been to court for one of these?
Still kind of getting my feet wet with
Yeah.
this.
Okay, so the way this works is we file a complaint. In that complaint, we have a date we get from the court. That's that person's initial appearance to come to court. And sometimes they're doing these by Zoom or phone now. Sometimes you come into court on, together in real life. And that's just the person's opportunity to show up and say, I'm here, I can test this complaint. the judge will say, do you contest this complaint? And they will say yes. Oftentimes, the person will not show up at all. And I almost always come prepared to deal with that through a default judgment. You know, I've often gotten judgments against people for like $40,000, $60,000 because they just didn't show up. So they're like, you know, Your Honor, it's $100 a day. It's been going on for 2 years. Sign the order. You never get that money back, but you know, you get the judgment. And the other thing that does is it gives us an opportunity to sit down with the person and try to hammer out something, some sort of deal. So I will often show up, like if it's a junkyard, I'll show up with a proposed consent judgment. That'll say, look, you know, if you get the cars out of there in 30 days, you don't have to pay us penalties. You pay a $500 charge and we'll be good.
Perfect.
Yeah, and then we use that appearance to turn in that now signed consent judgment. And that's the order on the case. Now, the difference is between that and a consent agreement. We'll talk about consent agreements in a second. A consent judgment now is a court order. If they violate it, they're in contempt of court. So if they continue to violate it, they could actually get arrested. Now, a consent agreement is an agreement that we make outside of court before we even get there. And that consent agreement deals with the violations. You know, they pay a fee or they pay our legal fees and they agree what they're going to do to, you know, fix the problems. So let's say for your tree cutting, if it turns out to really be a violation, we require them to get a replanting plan. We attach that replanting plan to the consent agreement. It's got its like, you know, re-inspection deadlines where we're going to come back and make sure everything's growing. They have to work with the forester. You know, they have to plant this many points. It's points to the shoreline zoning cutting. And that's all agreed to. And we're not going to wait for them to fix everything before we come to the terms with them. We're going to come to the terms, expect they comply. And then if they don't comply, that's its own violation. So now we're back in court. Okay. So I think that's the full life cycle of these things. The penalties are $100 to $2,500 a day. Judge is not supposed to allow violations to remain. But if we can make the case to the judge that, let's say a house has been built 15 feet into the setback. And, you know, it's not like unstable soil. To move it, it's going to be this huge excavation project and cost, you know, hundreds of thousands of dollars. We might be able to convince a judge that under this circumstance, it's an undue hardship to make them move. So we're not going to make them do that, but they do have to pay us a hefty penalty. Shoreline zoning in particular, with consent agreements and consent judgments, we impose really high penalties because otherwise people will just violate the ordinance and price it, right? It's just the cost of doing business, right? And shoreline zoning is super picky at the state about these things. I mean, it's really hard to convince them that, you know, something that's a violation shouldn't be fixed. So the judge is only allowed to allow something to remain if it's undue hardship or if it's going to cause environmental damage to fix it. Basically, the status quo is better than the alternative. And we get our penalties. We will get a court order that the person has to pay within a certain amount of time. If they don't pay within a certain amount of time, we take it back to the select board and decide, look, is it really worth our time to pursue this? I can go to court. I can get a disclosure against them, which is them saying what they can afford to pay. And the judge will say, okay, now you have to pay $50 a month for the next 10 years or whatever it is. Or, you know, if they haven't complied with the specific terms of what they were supposed to do, like I said, we can go back and hold them in contempt, or we can bring another enforcement action. Sometimes people just are not externally motivated to, you know, do what they're supposed to. They don't have the money to pay the fees. They don't have the money that it costs to do whatever they need to do to fix what they've done. And in those cases, it's just kind of a no-win situation for anybody. So we have to decide, is it really worth the town's money to throw at me when we're probably not going to see a resolution? So that's really for the board to figure out on a case-by-case basis. Okay, So I think that's shoreline zoning and land use. Floodplain, I mean, not terribly different. With floodplain management ordinance, if they're in the plain, they've got to make a permit application. If they don't do so, and they start doing what they're doing in violation of the ordinance, it really just proceeds along the same tax there.
Same line.
All right, let's talk.
Actually, oftentimes you get help from banks there, though.
Yeah.
Because banks will mortgage or refinance or whatever if without a permit issued by,
Yes, and that's where it comes up, right?
yeah, most of the time.
Yep. Either
But
they'll
I
go
think
get
a lot of the
insurance.
violations happen is when people don't have a mortgage and
Right.
they build an addition or something, and, and they're doing it on their own dime without a mortgage.
And as long as they already had their insurance, nobody's really asking a lot of questions. Yeah.
Right.
So same deal there, except for that we have the feds breathing down our throat on that. Storage of solid waste and junk. Okay, so,
Do you want a copy of what we actually enacted?
sure, I mean, I got it. I can pull it up there.
That's not a signed one, but I think that's the latest one.
So the difference with this is that they get lots of money, right? And it tells you exactly how much time they get. I prepared, I don't know if the board knows, but Dan has the first notice and the second notice. So
And he just has to fill in the
just has
blanks.
to fill in blanks.
Okay, so
Yep.
you already have that.
Yes.
Okay.
Yeah.
And that's exclusively for this.
Correct.
Okay.
So where do we go if we're saying, second notice, nothing's happening? We've burned up our time, where do I stand? Where's my authority go from there? Do I turn around and call you or?
So it's gonna go, let's see. It's a little, strange the way this operates as compared to most ordinances. So think of these fees, the 150, 250, 350. It's like getting a speeding ticket. You're not admitting to, you're basically admitting to the crime, and they're not going to prosecute you as long as you pay them their $150 for the speeding ticket. So that's kind of what this is like. No court obviously is saying that they're in violation. This is you and them agreeing that they're going to pay the penalty, and you're going to treat that as a warning. Okay, if they didn't pay the penalty, then I think it's fair game that we could take them to court. Whether we do so for a $150 violation is up to the board.
But I think what's more important, we want to get the place cleaned up.
That's absolutely the focus on this
Right.
stuff, right? And so, I have no problem, the board might feel differently if you don't jump right to the warning, if you try to talk to somebody first. And do the written warning if it's 2 weeks later and you haven't done anything. But once you go through that process and they don't fix everything, we have the authority to pursue enforcement action in court. We also say in this ordinance that it doesn't affect anything in the state junkyard law. So junkyards, it's like a third of what I do, it seems like.
I really question, I've got one right now where, I don't think I'm gonna be collecting $150 for a fine. I just don't think that's gonna happen.
And you don't think they're gonna clean it up either?
I haven't seen anything yet.
Yeah.
So,
And we've issued 2 letters, or
yeah,
you follow the timeline,
I
and
have-
you've
I
got
have.
all that documented and dated. and-
Yeah.
Yeah, and I think we're getting a fair amount of pressure to do something. else.
I-
You got another call
agreed.
yesterday
Yeah,
on
agreed.
another one, and,
Yeah.
and Terry, you.
I get sidetracked and tracks out of you the night by someone.
So I think that people realize that we now have this ordinance and they're expecting some results,
Some
particularly if they're living right next to
Right.
it.
Yeah.
I get it.
Thinking of your.
I guess, in listening to you, the $150 fine is, I guess, in my eyes, an admission of guilt.
Mhm.
And so I just think I'm gonna have a really hard time collecting that from somebody. Saying, okay, now you're guilty, and we're moving on, to phase 2 or
Okay,
phase 3.
The only way that they're getting out of this is if they clean it up, So let's say they don't do anything, they don't pay the fee. I don't think that we have to wait around for the third violation before we take them to court. We could, but we're not required to.
But would that be particularly if they say, I'm not doing any, I mean,
Yeah,
I'm not
If
paying
they're-
it,
if
and I'm
they're
not
just
cleaning it up, and.
not doing it, I'm not gonna do it. It's, a really bad violation, places a wreck. Let's talk about court. Okay, so court on dangerous buildings is just dangerous buildings and junkyards, the same problem, which is it's easy as pie to go to court and get the order that says you gotta clean the place up, you gotta tear down the building. It's very hard to get the person to actually do it. When they don't actually do it, we have the authority to come in and do it for them. But we often don't have the money to do that. So, let's say that this is a place with 10 junked cars and piles of junk, and, we're gonna have to get an excavator in there. It's gonna cost $10,000 to get the stuff out.
Mhm.
Great, we have that authority to go in if the judge gives it to us and clean the place up, but we often don't have the funds. So the 150 or 350, what is the board gonna do with that money when it's paid? Is it going into any sort of a fund, or,
I don't think we had that discussion.
we're not talking big bucks, and it's
No.
not gonna be like a lot of turnover of fees, but
And I think, personally speaking, I think our goal is more using that as leverage to get the place cleaned up than getting $150.
Right. I agree.
I mean, I would certainly be willing, I don't want to speak with Jeff or Sue, to sign some sort of consent agreement waiving the fines if they'll just clean the damn place up. I'd rather have them spend the money cleaning it up than paying us personally.
I mean, you've got that attitude, Dan. I think that if you say, look, you're on your second violation, if you get this cleaned up, if I come back here, I'm gonna write this off. I'm not gonna make you pay the $250. I think that's okay if it's okay with the board.
I don't want, I'm just one, I don't know how Jeff.
Yeah, I absolutely do. Money set.
I agree. But the problem obviously is with the people who just won't do anything.
That's-
And we'll cross that bridge when we come to it based on what it is, how much it's gonna cost, how bad it is.
I think we're there almost in a couple of places.
Yeah.
Yeah.
We're pretty
Well, if we
close.
wanna talk about that in an executive session, we can
Okay,
go over those.
Yeah, yeah, let's make a note of that.
The consummate problem with these though is really just how do we get it cleaned up? So I've had towns in the last year use ARPA money to do that. I've had towns create a property maintenance fund where some portion of building permit fees go in. All the violations and penalties that you get, they go into that fund. And then it builds and grows over the years. And if there's ever an egregious situation, we gotta take care of, at least there's maybe $10,000 there we can draw from. So that's something to think about if we have a lot of these that we need to plan for. So if we end up going to court, and again, this is on dangerous buildings and on junkyards, process is the same. We will get an order that says we can tear the building down, we can clean the yard up. And the statute says we can assess the cost of doing so against the property as a special tax. So what that means is on the next commitment that comes by, the assessor is gonna write as a line item, the town spent $3,000 cleaning up the junk from this property, $2,000 in legal fees, and $5,000 is a special assessment on that property. And just like any other tax, if it's not paid in the approximately 2 years of the foreclosure process, they can get foreclosed upon, and now the town owns the property. And sad enough, I mean, sometimes with these perennial problem properties, that's the only way of putting an end to it. So a lot of times it's worth finding the money, putting the bill, and knowing that, yeah, we'll get a pretty junky property at the end of it, but at least we can maybe sell it on the condition that it gets cleaned up.
Make money back.
Yeah. But often, particularly with dangerous buildings, like the older homes that may have asbestos and other environmental kind of issues going on, the cost of tearing them down properly can be $40,000-$50,000.
Mm.
And,
Yeah,
where do we find that
well-
kind of money?
Sometimes you wanna waive foreclosure on them.
Right.
You don't wanna own them,
Right,
because then you're responsible.
And since we're talking about structures, I'm sure you guys are familiar with that place over on Buttermilk.
Yeah, but I think we probably shouldn't get into.
Yeah, we'll turn that down.
We can talk about that in executive session.
Okay.
so let's talk about dangerous buildings, real quick. I think any questions on the junk ordinance? I think the important thing to know there is, if you go through this process in the ordinance and it's not dealt with, we basically kick it into the state junkyard law, which already has a process behind it, and we just treat it like a regular old land use action from that. We would probably I'd probably tell you, we've been through this process, they haven't cleaned it up. Let's do one more notice to say, we're taking this to court, select board has authorized it, and you've got another 20 days to do it.
So I'm thinking something like with a letterhead from your office showing up.
And sometimes at that stage, I'll attach a consent agreement that says you can sign this, But with the dangerous buildings and the junkyards, I feel much better about having something in court for those guys. Because they often just don't do what they're promising to do. And I'd rather have a judge be the one to enforce it. Yeah.
And we don't, under that ordinance, have the authority to add it to the tax bill. But you do under the other two, correct?
Correct.
Okay.
So dangerous building though, can be dealt with one of two ways. One is we do a notice of violation, and if they don't comply, we take them to court. We get a court order. We have the authority to tear the building down and assess the cost as special tax. We can also have the select board declare it to be a dangerous building after notice and hearing. And then that actually gives us the authority to go and clean it up. And even just having that threat is sometimes enough to, discourage people from continuing the condition, to encourage them cleaned up. So depending on a bunch of things, I might advise one course of action or the other. If it's a hoarder house and there's, a nice old lady living in it with a bunch of cats, and we don't want to tear the house down because a lot of stuff is going to go with it, we would probably want to go to court. If it's a vacant building that's been sitting there for 20 years and it's an immediate hazard, I'd probably say let's deal with it at the select board level. And some of it also depends on our real plans. We have real plans that we're going to spend town money and take that building down. So there's the court process. You might see that called the summary process in court. And then there's this select board process. Okay. Each of them can be pretty quick. I had a hoarder situation in Augusta. I think I had a court order in a day and a half, and she was, moved out with adult protective services, and the building was down within a weekend. So it can happen quickly. A lot of times, dangerous buildings, that kind of a situation, you have no way of knowing how bad they are on the inside, and then there's an emergency at the property, and emergency services go in and they see that all the conditions in here are terrible. And there are a lot
Something
of,
on one or two,
Yeah.
being able to walk in and, I guess, inspect it is pretty much out of the question.
if you have, you can't just, walk in, but if you have reason to believe that it's bad, then you can, ask for permission to enter. We've also got the local health officer. So for things that are really bad health conditions within a property, I like to use the local health officer, do an inspection together so that you're looking at building things, building elements. That person is looking at things like vermin, mold, is there human waste around, stuff like that. And the reason I like the local health officer involved is they actually have the ability to post that building right on the spot and say, you gotta get out of here.
And we actually have one now.
Well, that's helpful.
And he's a doctor.
Very good. Yeah. Let's hope you keep them after the first time.
I
You
know.
get every one of these places.
Good, yeah. So, yeah.
Yeah, so that kind of situation, that's a really good thing to take advantage of. And then once you got that
Good
building,
idea. That's-
yeah, once you got the building posted by that health officer, if they don't move out of the house, then you can actually use law enforcement to encourage them to get out of the house, because that authority is in the health officer that you actually don't have.
Well, I have a question though. So if we got a bunch of garbage, literally garbage, trash outside, with maggots or whatever, I would assume it doesn't have to be in the building, and the health officer can also,
Absolutely.
okay.
Yep.
So that's something,
If you've got.
he won't be, no, I'm only kidding.
You've got trash, let's give the examples, like it's on the porch, it's trailing out into the yard.
Mhm.
I think that could be health officer.
Good.
It could be this ordinance, the waste ordinance. We can deal with it a lot of different ways.
Yeah, but there's nothing hurts coming at it too much,
Absolutely.
You're right, yeah.
because if one doesn't work, the other might.
Sure.
Yeah.
No, I like the angle with the thinking with it.
Yep. Getting a building posted like that, a lot of times is real helpful too, in encouraging the state to actually do something to help somebody. So if they actually literally do not have a place to live, that's really the only time the state will step in. So you can have all the evidence in the world that a person is living in squalor or in unsafe conditions. And as long as they have a house, in my experience, and even if there are kids involved, it's really hard to rely on the state to put an end to it. But if they're getting kicked out because there's an order posted on the house, that helps. So I think that's that. I spend a ton of time thinking about dangerous buildings and junkyards and how to better handle them, because again, the process of getting that court order is just fine, it's easy, but what we do from there is really, really hard. So, the town attorney in Vassalboro, we had this situation with this dangerous building. It was looking to be like, not a hoarder situation, but people were squatting in the house. It was just dangerous. And it was, $40,000 is what we were thinking to take it down. It ended up being cheaper. But they actually did go to the voters and ask for that $40,000, and the voter gave it to them. So depending on where it is, how bad it is, it may be worth, getting the money to do it. So very case by case on this stuff. All right, town landing, I do not know this ordinance, so.
Yeah, basically, Jeff, you're pretty familiar with it, right? I mean, it's I don't know. This is one of those things that kind of flares up and down. People, there's an ordinance that you can't leave stuff there, you can't leave book stuff there. We haven't had a lot of issues lately.
No.
But then all of a sudden, we'll have a bunch of them. It seems like it kind of goes like this. And people leave boats there, or they'll leave trash there,
Or trade.
or trailer. And I don't have that ordinance with me either,
I'm looking at it now.
but,
So this says, the CEO may at the owner's expense have any personal property that's left there removed and relocated to another part of the public landing. I don't know how feasible that is.
well, we've actually hauled stuff out back before, and we let it sit there for like 6 months. Nobody claims it, it ends up in the dumpster. I mean, it's just, basically, you obviously we would have to hire someone to do it, and that also ticks off people, because boy, we're paying to haul away somebody's junk boat.
Yeah,
But it's hard to find out who owns them sometimes. Sometimes it isn't. Sometimes they leave the numbers on, and Terry can get them from
state.
the warden sometimes, or
See,
the state, right, whatever, you get them somehow, but sometimes they're stripped of any identifying marks. But right now, it's not a huge problem. I think right now our bigger problem is the junky yards and trash and stuff, so we can move on. I just wanted to touch base, because I wasn't even aware, you were aware that that's part of your duties. And if someone calls Terry because someone has left something there, you know, she's gonna refer to you and I didn't want you to say, what's this all about?
Right, yeah, and part of it does authorize you to allow people to park. overnight. You're not allowed to leave anything there overnight unless they get permission from the CEO.
Okay. We actually had an incident.
Recently.
Yeah,
Not too long ago.
Yeah. Explain that real quick.
Yeah, that somebody put a trailer there, had no markings, locked it up, it could not have been towed. And there was no indication who it was, and it was parked right in the middle of the lot, which means right in front of the lobster shack, or the lion shack, which means that the lions could not operate out of position. And it turned out it was a contractor doing something for the people across the street. And so all I did was put the ordinance on, take the ordinance to it. They saw it, called. So nobody had given permission. But we have, it used to be the select board, I thought, we could give overnight permission, so I think we changed it.
Yeah, I thought we did too. We don't meet for 2
Right.
weeks and someone doesn't, they don't want it 2 weeks from now, they want it tonight.
And just so you know what the philosophy was, we don't really want anybody parking there overnight.
Yeah.
But if somebody there, the one exception we have made in the past is there's an apartment above a big store and somebody lives up there and there's nowhere else for them to park, and so we allow them individual to park in the parking lot as long as it didn't block anything.
Sometimes people will launch a boat and they're going camping overnight or something,
Right.
and they want to park a trailer on the side there, and they're technically supposed to come to you. But some people abuse it and some people don't, and that's,
It seems to me that we used to have it posted that vehicles left overnight could be towed at the owner's expense.
Yeah, I think
And
we
a
did.
phone number for who would tow it.
Yeah. think we
I
did.
don't know if that sign's still there.
but again, it's one of those issues that plays up from time to time. Right now, it seems quiet.
Yeah.
So I'm not thinking of something like that, it's just pretty much judgment call, you know, with contractor. Hey, it's just gonna be there for the night, no harm, no
But
foul.
don't put it
get
in
it
front,
out-
but don't
yeah,
put it in front of the line.
Get it out of the way, and, yeah,
And,
okay.
and that's something, it's easy to call one of us and say, hey, what do you think of this? I mean, that's-
The only little red flag that goes off with this ordinance, for me is, when you're taking anybody's property and storing it on town property, when it finally comes time to get rid of it, there's actually a ridiculously convoluted process about abandoned personal property like that. So we're supposed to post a notice in the paper, you know, we'll leave it in our judgment, I think, based on, is it, you know, a skiff that is basically lumber?
This boat was
You know,
going nowhere.
Exactly. And there's no indication of who it belongs to, you know, we're not gonna go crazy with that.
The one thing you do have to be careful is messing with lobster traps with tags, you know.
Yes.
And they leave them down there sometimes, it's totally destroyed, but the tags are in them, and I think the wardens,
It gets touchy.
yeah. Because I don't think it's the trap that's actually the problem, it's the tag. Am I, if I have this right?
Yeah, there's
Yeah.
something there that, because that tag, someone could take it and put it on another track.
Yeah, or something, I don't know, so you gotta be careful with that, and you can usually get a hold of the warden, right?
Usually, yeah.
So if there's traps involved, you might wanna talk to Terry.
Yeah.
And sometimes people will leave traps for 2 or 3 days on there, and they're not supposed to do that either.
No,
I
no,
mean,
it's-
a lot of times you do, I think just a phone call.
Yeah.
Well, if you can figure out who it is, it's like, you know, you can't leave your traps here for a week, you know? So. Okay, we ready to move forward? And, yeah, more questions on the enforcement stuff, or we spent quite a bit of time on that, which I think was good, but again, I would always encourage you to talk to Kristen, particularly if you think it's gonna get complicated.
We skipped subdivisions, but I guess that's also in the, state statutes as well.
Yeah, is there a lot of enforcement issues with that, though? I mean,
Yeah,
There can be.
absolutely. So The hard part is finding the illegal subdivision in the first place. You know, in a big town with a lot of resources, there are people who can spend more time with assessment cards and stuff like that to see where divisions have occurred. But where you'll see it is if somebody comes in for a building permit and you see, oh, this is a new lot that's been divided, because they don't have to come in and get permission to divide the lot in the first place, right? So they divide the lot. Yeah, it might be caught on the assessment side of things, but it may not get to your
Never
desk,
gets
right?
to, yeah.
Right, so they come in to get a building permit, you look at that lot, and then you go back, you work with the assessor, you can work with me and try to figure out deeds, but if you have indications that, oh, this is the third lot that's been developed out of this place in 5 years, then it is an illegal subdivision. You can't get the building permit because of that until they go back and get subdivision approval.
Which needs to be done in the planning board.
Which needs to be done with planning board. So like a lot of things, you know, planning board handles permitting, but if they haven't done the planning board permitting, then now it's on your desk as an enforcement matter. And the remedy is usually come get the planning board approval. But sometimes, you know, there's been violations going backward that are sort of egregious, and we want to deal with like a real violation and assess a penalty against them. So like I've got one in Wyndham where it's, I think 60 some lots were created over a period of time by, you know, gonna give this lot to my daughter, this one to my son, this one to my son and daughter, this one to my LLC, this one to my trust. And, you know, over time that can really blossom into that sort of thing.
Sure.
Here we would see it on a smaller scale. Little red flags though would be that kind of thing where you see somebody giving it to a family member, somebody giving it to an LLC that they're clearly a part of, you know, things like that. But there's a lot of that in this region of trying to use the family exception to the subdivision to get around having to get subdivision review. Okay, and so the way the law works is, yes, you're able to exempt lots that you convey to family, but it has to be bona fide. If you're doing that and then just turning right around down the road and selling, you know, if your child is 3 and he owns 4 lots in a subdivision, that's looking a little weird, right? So if your intent is to avoid the subdivision law, then they're in violation.
I don't think we've had a lot of problems with that here, at least not that we're aware of.
That's the hard part.
Yeah. But I mean, Kevin, I think would
I think you picked
pick
that up.
that, he's our assessors agent.
Yeah.
He's pretty good at picking that kind of stuff up and kind of either coming to you or, so, because he doesn't work anymore. Left the company.
The other thing to keep your eye on is just changes or amendments to subdivisions. So are they proposing to change lot lines within a subdivision? Are they proposing to take a road and build on it and move that road somewhere else? If the developer of the subdivision is still in the picture, they're still developing lots, but they're building out those lots, making those divisions in a way that's different than on the plan, or if they're not doing the improvements that the planning board required, that's a violation for that developer.
It's an interesting, you know, with that, I hadn't thought of that with moving a road or stopping somebody the other day. But it's a pretty good sized lot. Actually, yeah.
So if it's
Interesting
anything,
conversation here.
yeah, if it's anything that's depicted on that approved plan and the developer is looking to change it, there's a problem. Now, let's say it's approved plan, there's no condition on that plan that says any change has to go to the planning board. And lot owner 5 years down the road, somebody who bought from the developer, wants to divide that lot one more time. They usually don't have to come back in and get subdivision amendment. And they're not treated as violating the subdivision plan because they're not the developer. That's just a funky thing under the statute, that it really focuses on the developer. But now if you've got somebody looking to put 2 lots in one of those subdivision lots, then they're creating their own subdivision within the subdivision. and it would be treated as an amendment. So these things can get complicated. But then, you know, if you have the person who happens to own 2 lots and they're going to make actual structural changes to the subdivision, like a road or something, then even though they're not the developer, we might require them to get the amendment.
Well, actually, now that you mentioned that, moving a private road, you gotta be careful that you don't create a non-conforming lot.
Absolutely.
That's not even in a subdivision, but I mean, you could have, you know, a lot that's just barely 2 acres, and then you move the road and take 15 feet of it.
Yep.
You've just created a non-conforming lot.
Sure. Sure.
It's complicated.
Yep.
The other enforcement action on subdivisions is, it's just like a conditional permit or anything else. If they put on the subdivision that you require, that the developer is required to put in a pond for the fire chief, or to widen a road in a particular place. Whatever the condition is that's put on the subdivision, that may not happen initially. You won't see it for a couple of years. Because they're developing lots and not thinking about this portion of it. So you could easily have some enforcement action because they failed to do one of the conditions that were highlighted. So anytime there's a subdivision, you should not only be involved with the planning board, you need to see all the conditions.
So subdivisions, it's a violation for anybody to even advertise a lot that would be in a subdivision, meaning, you know, they're looking to sell 2 or 3 lots off of a parcel of land. And you see that posted with a realtor or for sale by owner. That in itself is a violation. They don't even have to convey that property out and create the division before it's a violation.
But if that's done prior to getting approval for something.
Correct.
Yeah.
Yep, they gotta go get approval before they can even advertise.
Advertising, right, yeah.
And subdivision law also pertains to, this is becoming more common, divisions by building. You know, somebody wanting to put 3 Airbnbs or something in a single family home. If each one is dwelling unit, meaning it's got sleeping, eating, and bathroom, then they've created 3 dwelling units in a single property, and that itself is a subdivision as well. If somebody put up, you know, a big brand house and 2 guest cottages that are independently dwelling units, we could call it a subdivision if they're leasing those out separately to other people. If they're just using them as guest quarters, then no, but if they're
What if they're
Airbnb,
temporary rentals?
even temporary,
Yeah, that I can see that happening, yeah.
yeah, I definitely can.
Sure.
There is a law saying that if you have site plan review and that type of a building-based subdivision is subject to site plan review, you don't have to review them as a subdivision, but one way or the other, it would still be a violation if they didn't get approval to do that.
But I don't think we have.
No, we need one, but we don't.
Yeah. I mean, technically, they submit a site plan, I suppose, but it's not for a fulsome site plan review process, right?
So I'm gonna move this along a little bit, because
Okay.
we spent a lot of time on that. So just jumping back, and I put other here too. So I think certain things that clearly don't want to do in your, I mean, one of your roles is to provide assistance to the public, obviously, but in interpretate, and, you know, helping them interpret the ordinances and, you know, so on and so forth. But I think you need to be very careful of, and front office as well, because people are always seeking legal advice, as we know in the front office. You obviously don't want to give them legal advice. I mean, a lot of times the answer is you really need to ask your attorney. And people will push, they'll push and say, well, can I do this? Can I do this? And, you know, and then all of a sudden, 2 months later, when they're caught in a violation, they come back, well, the code officer said I could do it. And it kind of puts you in a tough spot. So, I think the other thing you don't want to do is get involved with property boundary determinations. People will often ask for that. The answer there is you need to hire a surveyor. And I think It also applies to the front office, and then people also want to use the tax maps and surveys, and they are notoriously inaccurate. Tax maps are, they weren't created as surveys, they were created as simply sort of order of magnitude for tax purposes, not for boundary survey purposes, and people don't get that. Even the real estate, they're probably actually the worst, right?
Yeah.
I
don't want to get a survey, they cost too much money.
Yeah, but your tax map says my boundary's here, well, yeah. And then I think another thing is, approval or denial of any permit application should only come pursuant to a written permit that it's complete. And I think there's probably many other things, and if anybody else wants to jump in, Kristen.
Oh, I've got a lot to say about what you did, a couple of things.
All right, well, go ahead.
So but you told me I could do it thing, it's not just a political problem for you. It's, if we then try to enforce against them, there's this rule called equitable estoppel. And the rule is, I relied on something that someone told me in writing. Writing is really important. It wasn't just like, passing in the hall information. It was, I was being serious when I told you this. So if I relied on you, you gave me something in writing that led me to do what I did to my detriment, and now you're trying to enforce against me, that would actually block the enforcement action. Okay, so when you're giving informal guidance to people, I prefer not putting things in emails if possible, unless you're talking about, you got to submit X, Y, and Z, more procedural kind of stuff. But just watch out for saying, I think you're good if, or, as long as you do X, Y, and Z, it'll be approvable. Or I think that's allowable in this district, unless you are 100% confident. Don't put something in writing, basically.
And the facts change too. I mean, somebody, people
Absolutely.
come in with a set of facts that are A, B, and C, and then all of a sudden it's D, E, and F.
So
And-
that's actually reminds me of a good piece of advice, which is, if you're going to put something in writing that's an answer to a question, summarize exactly what they told you in that same, email or
Spit the question
writing.
back. to us.
Absolutely.
That's a good idea.
Yep. Because it does often change, and you'll be like, no, that is not what you told me. And so I told you X, and now you're proposing the other thing. Obviously, the answer is Y.
Which kind of why I say don't issue or deny a permit until you have a complete application and act on that application. But
Yeah, so denials of applications. You need to, how the planning board, when it denies an application or grants an application, has to do written findings of fact. The courts are being extremely picky about code enforcement decisions. So that includes things you do on enforcement, permit denials, permit grants, and conditions. And so what they want to see is some explanation, if you're denying a permit, written out as to why you're denying it. Okay, cite the code, cite whatever it is. If it's a building code problem, cite the provision of the code. Sometimes it's okay if there's enough back and forth and information in the file that it sort of bolsters your decision on its own, but we always want to try to put it in writing. Same thing for enforcement. So if you put a stop work order on a building and now you're deciding to lift it, a little more than just I'm lifting the stop work order is helpful in case some neighbor wants to challenge it down the line. So I'm lifting the stop work order because you provided this information that I needed. You received your planning board approval, whatever it was. So that's helpful.
other things that the code enforcement officer shouldn't do?
Let's talk about planning board interactions meeting. Is that premature on your agenda, Jen?
I don't think so. No,
I just
'cause
think
after this, I kind of wanted to walk through some of the highlights of the land use ordinance. And I also, before we leave this, I want to talk about the permit application form itself, so go ahead.
Okay.
I'm not sure where you're going. but-
I'm not sure where I am either, but I mean, some of this is exploratory. you know, in towns that have a planner, life is grand. You know, the planner works with the planning board and it's totally separate from codes. In your role, it gets complicated sometimes, right? You might have some enforcement stuff that's percolating on a property, but then they're actually in front of the planning board and you're advising the planning board about the application. So I see in your situation, I see your role as helping to gather the information, the application, make sure they have all their materials in, get it to the planning board, and then the planning board 100% takes it from there. You know, they can ask you code questions. Do you go to planning board meetings?
do.
Okay. So they can ask you code questions. You're there as a guide, but you're not there to tell them how to decide at all. You want to shy away from talking to anybody but the chair on the planning board about an
Can you repeat
application.
that? I didn't hear that.
Shy away from talking to anybody on the planning board except the chair. And even when you talk to the chair, it's really about procedural stuff. You know, this application is teed up and ready to go. You know, this is missing this piece that I requested of them. This person came in and asked me this question. But if you had concerns about their ability to approve an application, that's really something that you should bring up in front of the meeting itself, or in writing in a way that it can be distributed to the whole board. But the planning board's rule is it can't talk about an application outside of the meeting, and even to you, even to a staff member, even to the select board. So any member of the public or town staff should really be, you know, off their radar unless it's something. Okay. And then if you have real grave concerns about an application, you know, feel free to outline those in some sort of a written memo or something so that you have something you can share with the board and they can think about before a meeting. That's totally okay. But as long as everybody sees it, that's really the crux of it, is to make sure everybody is thinking of and acting on the same exact body of information on the plan board. So actually, I think that's all I really wanted to say about planning board.
Okay. All right.
I do want to add one more thing. on the plan. You're the first gatekeeper for those. So in the land use ordinance, there are some things that are CEO action and some things that are planning board action. If it's a CEO action, you don't want to go into the plan. You need to take the action on that. And it's the same kind of conflict. If you take something to the planning board that is not their purview, and then they discuss it, now you have been tainted by the planning board's discussion of that particular item. So one of the things you need to be careful of in the near future is making sure that things that go to the planning board are in fact planning board permits, not CEO.
Yeah, and
That
that's,
is absolutely grounds for lawsuits, is if the planning board tries to or does approve a CEO.
and that's, we're gonna, when we get to the table of use, which I want to review in detail in both the land use ordinance and the shoreline zone, that's pretty clear. Although sometimes, and that's one thing I want to talk about, is sometimes a use doesn't fall neatly into any of those table of uses, and I want to talk a little bit about how the code officer deals with that. I mean, and I'm just going to use this as an example when we get there, but I have a couple of examples which may actually spill into executive session. But okay,
Oh, and enforcement stuff, I don't know if this town has a problem with it, but I have some small towns where the planning board thinks they're in charge of everything planning and code, and will try to meddle in enforcement actions. You know, they'll let people come complain to them about something, and purport to be the ones to take care of it one way or the other, or pressure the select board or the code enforcement officer. If you see that sort of thing happening, I think probably the best thing to do is to talk to the board about it. Since the board is the appointer of the planning board and can sort of guide what they're doing more than you can. So, certain boards, certain people on planning boards kind of are a little bossier than others in this situation.
yeah, I think that's a good point. I think that's important to remember, that the planning board is not an enforcement agent at all.
Not at all. They cannot even hear a complaint. They should, if somebody stands up at a planning board meeting and wants to complain about something that's happening, you know, that's not an application, they really should be cutting it off right away. Saying, talk to the code enforcement officer.
That's an
Not our job.
enforcement action, right? Yeah. And I think it really gets complicated, though, and I think you alluded to it earlier, is when you could have an enforcement action going, and they also have an application in front of the planning board that might make that enforcement action moot. Or might
Or
not.
vice versa.
Or make it
yeah,
worse.
or right, or make it worse,
Or
right?
you've taken a different position as a matter of enforcement than the planning board looks like they're gonna take in terms of what's legal and what's not. That could get awkward too. Not saying what you should do in that situation. It's kind of hard, but we'll figure it out.
Okay, so I'm gonna, unless somebody has anything else on the other things that are sort of related to assistance to the public, I'm gonna move on. Obviously, again, I don't want to state the obvious, but maintaining the files is critical. We have a file system here where property, each parcel has a file on it, and it has assessment records, it has any letters that might have come in from DEP over the years. Really, anything that sort of relates to that parcel is, and it's critical that stuff gets filed in that, which is not to say that you can't keep a notebook of permits you issue or applications in some other order. And actually, I think it's a good idea to do that, but it's also, you know, two systems is fine, but I think it's critical that those files are maintained and people don't take stuff out of them and take them home. I know when I was in Waldeboro, we had a lady who was in charge of those files, and she would cut your hand off if you anybody. It didn't matter whether it was a select board chairman or the town manager. She was like, at the end of the day, if stuff wasn't back in those files. Yeah, and so that's kind of critical. And I know, I think Kevin violates that a little bit as well. Yes, that's his agent. But anyways, I just can't say how critical enough it is. Obviously, you have to process fees. I think that's working out with the front office, okay?
I think they've worked.
The flying fees, because I know in the past we've had problems, not with necessarily with Dan, but, and then we good there?
I think they're working on a system.
Okay.
I don't hear that conversation very much
Yeah.
because I'm behind the wall and the air conditioning.
But all of a sudden, we get a letter from the state plumbing people saying, you know, we owe them $600 or something, and it seems
Like that.
and it seems like you guys then spend 3 days trying to sort out this $200.
Yeah, I think they're on top of all that.
Okay, all right. And then there's the expectation that you'll prepare monthly reports to the select board and the planning board, which is actually in the ordinance, I believe, that you'll. So those are kind of the duties as I see them.
Part of the process of these is that if we don't have, we have a document that says here are the fees and fines for everything, right? And you come across something that isn't on that list. Or you look at it, you go, you know, we're only charging $5 for this particular thing, and we need to charge more than that. Bring that to the select board, and I don't think we're gonna argue about it. So it's a procedural thing more than we are expecting you to come to us to update that.
And actually, Dan did that very early on. He put together a kind of fee list comparing us with other towns. And I actually encouraged him to hold off a little bit because we had had such a hard time even getting a code officer that issued permits, that people were so upset that I said, the last thing I wanted was increase fees when we can't even get a permit issued. I think we're beyond that now, so maybe we can come back to that. But at that time, I mean, remember people were coming in and they were, you know, well, what do? You got no code officer. And I said, oh boy, we're gonna really pour fuel on the fire. We increase the fee and we can't give them a permit. So, so we can revisit that. I just put the students on here, relationship between the land use ordinance and the shoreline zoning ordinance. I just want, and Kristen, maybe you can help, I help out a little bit. The way I describe this, and perhaps it's wrong, is our land use ordinance applies in the shoreline zoning ordinance as well as the shoreline zoning ordinance. So I look at the shoreline zoning ordinance, in my mind, as sort of an overlay.
Yes.
Can you talk about that concept a little bit? Because I think a lot of people think they're sort of separate, and they're not. And the most restrictive would apply, as I understand it, at least back when I was on the planning board many years ago. But you talk about that concept a little bit?
Yeah, so you described it exactly as I would. If you think of the zoning map for the town, you know, we do have zones, and they apply whether that property is in the shoreline district or not. And then the shoreland is an overlay for the areas 250 feet or less from water. And those standards under the shoreland apply in addition to the land use ordinance. So that's exactly the right
So if
way.
you're in the shoreline zone, you're gonna be looking at both.
You gotta be looking at both,
Okay, yeah, not just the shoreline.
which is why you see a lot of towns that just have one sort of, you know, granddaddy land use ordinance that incorporates the shoreline zoning stuff, because sometimes people have a hard time, you know, managing the two ordinances because there's conflicts. But where there are conflicts, the more restrictive controls, I always err on the side of shoreline zoning. You know, if they're not necessarily in conflict in the sense that one is stricter than the other, but one is clearer than the other, I err on the side of shoreline zoning.
Well, and there is a major, I mean, I won't call it conflict, but the table of use is quite different. I mean, the shoreline is, if I recall, unless it's changed, is much more expensive than in our land use ordinance. So, you know.
And I would suggest probably trying to integrate those at some point.
Now, the last changes that we did bring both of the processes the same. So that if you're looking for what the CEO does or who does what, it is, and definitions. It's reflected the same in the shoreline zone as it is in the land use ordinance. So,
We've been moving in that direction.
right, yeah. So that doesn't mean that there aren't still some conflicts and some differences, but procedurally, the process is almost identical. Say almost 90%. I think it's captured it all.
How are we doing time-wise? I have to 5:45. I don't know what other people have. Does anybody have to be out before that? Okay, and Kristen, you okay with 5:45? Okay. So what I was hoping to do now is if everybody sort of had their land use ordinance in front of them. And I don't know that everyone does. Do you?
I don't have
Yeah.
one.
I was hoping to sort of walk through some of what I saw as some of the key elements here, but I also want to leave time for that executive session. Do we have to do the fire tonight if we run out of time, or can we put that up Tuesday?
No, but I think we should,
Other than maybe say,
we want,
let's refer these documents, yes, Chris to take a look at. Okay, so we don't have to have, you're not thinking we have to have a half an hour discussion?
No.
Okay. I just wanted to ask, because you're the one that put that
So
on.
do you
So,
hold it? Okay.
so, and I think, Dan,
Dan needs
that
one
one
too?
either, you don't mind. But, and I don't, again, I don't want to walk through it page by page, but I picked out what I wanted to start with some of the definitions, which are, and I put the pages down, they start on page 15. I didn't list them all, obviously, but I think there was some critical ones. And I think a lot of these apply to the shoreline zone as well.
should be identical.
But I guess I'm on the way, it doesn't make much sense to. While we're waiting for that, on the form, which is required, the permit application form, I had, and this is something that I am the CEO can change. Is that your understanding?
Yes.
I had two suggestions, and they're quite simple. One is, it says that a chimney will be built, and then it goes, if yes. Up here, it says yes or no. It just seems to me procedural, it would make more sense to have a yes or no there as well. That's very minor. But on the describe in detail the work you will be doing under this permit, I think it would be very helpful if they would actually list the use as listed in the table of use, at a minimum. You know what I mean? And I don't know how others feel about that, but, you know, maybe we can, if we have time in the end, we could talk a little bit about that, because, I mean, I think if someone says, you know, I can't think of a good example right now, but, you know, build garage, well, is it for an accessory structure? Is it an accessory structure for another use? I mean, I don't know. I just think we should try to be more specific and align with the table of use on that application, but we can come back to that. So, and if anybody else, as we go through these definitions, thinks there's others that are kind of critical, please jump in. I started with a budding property. And I guess I just wanted to be clear, because I had a couple questions on it. But I mean, when we're talking about a budding property, we're talking about a property that physically abuts, touches, but even if it's at just a point on a corner. So does everybody understand that concept? I mean, it can be, you know, and it does say also across a public way, but does that mean it does not include something across a private way?
A private way is quite often, but not always, going to have property lines that meet in the middle underneath that private way. So they are technically abutting even if there's a right of way over top of it. But there could be a situation, sometimes with subdivisions, for instance,
With
the developer will keep a road that's either kept in the developer's name or given to the homeowners association. So now there is separate ownership by deed of that road, and the people on either side don't actually touch.
So they don't abut.
So they don't abut according to this, which is kind of, doesn't make sense. Might be something to clarify.
Right, but currently that's how
Yeah,
Dan would have to deal with it.
Yeah.
Those would not be abutting properties.
right. If we absolutely have to, we can look at the deed and see if it describes it as going to the edge of a road or to the center line. But the other thing is, I mean, a lot of the times this comes up is just for a butter's notice, that kind of thing, and erring on the side of giving somebody notice is never a bad idea. If it's about setback from a budding property, that I guess would be the practical.
Yeah, and we don't really have setbacks, but only in the shoreline.
I tell people, we go with the state setbacks.
But not in the land use area, we don't. We have no setbacks.
Or when it comes to setting structures next to a property line, you know, like whether it be a shed or something.
Yeah, that's my point. We have no setbacks,
Yeah, no setback.
except in the shoreline zone, right?
Except in the shoreline. Okay.
So, yeah,
I've been
but the
telling-
problem,
It's associated with the water, the body of water.
right,
Yeah.
yeah, not structures.
Yeah.
The problem with that, so I don't think you can tell people that, but the problem with that is, it's not up to you to determine where the boundary line is.
Oh, no, no,
So,
absolutely.
so
Yeah.
if they sort of, if they put a build a garage, they kind of, and they're right up against the line, and they're not sure exactly where that line is, they're kind of doing it at their own peril with their neighbor.
After that,
But it's more what I'm referring to, because I think the state is 6 feet.
I'm not
I do
aware of that,
believe, but you know, from what I've read, but until, you know, it's like Rockland is 10 feet, that's what I recommend to people. You know, if you're gonna do it, set it back at least 10 feet from your known property line.
but I don't think that's something we can require. Right.
No, it's a good rule of thumb. but
Yeah, that's,
Not
yeah,
wrong.
Yeah.
rule of
Yeah.
thumb.
And even that,
it makes common sense to have some kind of setback for your own protection, but it is not a requirement.
right,
Yeah.
Yeah.
Somebody can put it fence or a structure right on.
However, actually, let's talk real quick. I know it's not out in the ordinance, but let's say there's a property line dispute between two owners and somebody's come in, they want to put a garage that extends into this disputed area. Okay, that can be extremely tricky for you, right? So all they have to do is prove to you that they have a deed that purports to contain that area. And so if they come to you with a survey and say, look, this is what my survey says, and this is what my deed says, and you're not a judge, you can't look at what their surveyor provided as compared to what a different surveyor provided. All your job is to make sure they have some evidence that they own the area that's reasonably believable.
Yeah, reasonable.
Right. And if it is reasonably
It
believable,
can't be my grandfather told
yeah,
me.
yeah, if it's reasonably believable and you've seen a document or a survey, and it's a survey by a real surveyor, then you are totally free to issue that deed, even if you know that it's going to spark World War II between the neighbors. I'm sorry, not the deed, the permit. What I would like you to do, if you're giving a permit under those circumstances, is write out more specifically. You know, there may be a property dispute between the abutters as to the precise location of the boundary. This permit is issued on the basis of, you know, the deed and the survey that were provided to me. Okay. At the end of the day, you're not held liable for making judgment calls like that, but it's good to have it in the record. Be clear. And I advise the planning board to do the same thing.
Okay, I'll move on. Accessory use of structure, I think the key thing there is that you can't call something an accessory use if it's the primary use. And that sometimes is a problem. I mean,
Yep, watch out for the Airbnbs with that. Somebody will build a smaller home and say, oh, but it's accessory. Okay, well, but you're also renting it. Even if it's not Airbnb, if it's just a separate rental, it's going to be a whole separate family using that property. I don't qualify that as accessory. If it's for grandma and grandma is going to be using the home for things like laundry and other things like that, I'm okay with it being accessory. So judgment call based on how they plan to use it, and feel free to ask all of those questions to get to the bottom of it.
and if everybody wants to grab any, go ahead, because I jumped down here to building and I point out which is different than structure. And I'm not actually sure why we have two in there. Maybe there's a good reason, but building any structure having a roof or partial roof, supported by columns or walls, used to enclose persons, animals, goods, or property. And then if you go to and which includes a multifamily zone, but then if you go to the end, we have structure. That's all we did. Yeah, the last one. Anything constructed or erected with a fixed location on or in the ground, or attached to something having a fixed location in or on the ground, excluding driveways, walkways, patios. So I guess the key difference is here, it doesn't have to be to house people, animals, or activities, but it certainly would include things that people do not often think of as structures, such as storage facilities that are manufactured offsite and set there, and the intent is that they stay there.
Like a container,
Pardon?
a
I mean,
container.
if you're doing it, you're moving and you're putting there something there for 2 or 3 days, that I don't think that meets this definition. But if you set something there, and quite frankly, it probably even includes canvas structures with poles. I mean, I don't know how far we want to push this down, but
It does, it includes septic systems according to DEP. So, you know, the tank itself is a structure.
no, we've never had people pull building permits for a septic tank.
Well, because it's not a building, it's a structure.
Right. But
But isn't that covered in the HG, you know, the 200, yeah.
But my point is just, you know, things that you wouldn't really think of as a structure are still a structure. If it's there, if it's fixed in the ground.
but you need a building permit for a structure.
Or for a structure or for building.
But
This goes to that discussion you might have. In many ways, it's a word game. We identify permits by use, even though we permit by something other than, for example, a structure, storage that meets the requirements. Let greater than 100 square feet, has the walls covered over, you're going to store something that requires a permit, even though there is no use specified.
But that's where I get confused, because if you're building a building, if you're not gonna use it for anything, you're saying it doesn't need a permit?
No, it's greater than 100 square feet.
So we do require permits for buildings, or if it's a structure greater than 100 square feet.
Correct, but our land use identifies required permits by use as opposed to by what the structure.
So I'm back to my original question, then. If you put up a building and you don't have a use, you don't need a permit.
Well, in almost all cases, you're gonna have some kind of use.
Well, I know, this concept confuses me in our land use ordinance, and it always has. And it sort of ties into why I think we should have use listed on a building permit application.
The only issue I've got with that is I think that's the CEO's job, is to identify what use is applicable. When somebody files a permit, that they aren't, rarely are looking. Should.
No, I think it should be, but yeah.
Yeah, that is odd. It's conspicuously missing a building permit section in this ordinance, at least that I can find, right?
Correct. And I can tell you why it's not in there, because this town did not want
Well,
building codes applied. That was the reason that it has never been there. And it had been thought, it had been discussed.
but that's why I bring this up, because I think it puts, if I was the CEO, I wouldn't know how to deal with this.
Well, I mean, you just go to the,
You go to the table.
you go to the table
Well,
for
yeah.
what it's gonna be used for, because that will determine
Yeah,
who
but,
does it.
right, but then you said, you had, and we're getting back to our conversation, you said that we didn't need to list, if I heard you right, single-family homes as a use.
We do that.
I know, but,
Yeah.
but I thought I heard you say that doesn't need to be listed
No, I
as a
think it
use,
does.
because,
It does.
okay, well, and that sort of solves my problem. Because that's what I misunderstood, because if you're building a single-family home, then that needs to be the use listed.
Correct.
Okay, that sort of takes away a lot of my problem. Always learning. I'm gonna move on then if we're good. I don't know if you're good, but
Yeah, no,
I'm not. I mean, I'm not good, but I'm better than I was. Okay, commercial use.
Before we go to commercial.
Yeah. Sure, jump.
We
Take it.
have campgrounds and campsites.
Mhm. We do, I don't see campsites.
On page 17.
It's right below campground.
Right,
I have cemetery.
You got the old.
Ah,
you got the old copy.
This is signed June 3rd, 2021. It's the one you're passing out, right?
I just,
No, she just gave us
I
one.
think,
Are you looking at the table?
No, I'm looking at the signatures in the
Oh,
date.
no, I'm sorry, in terms of the campground campsite thing.
June.
No, I'm looking at,
15,
no, I'm looking at
It
definition.
should be 15 June. 15 June.
So there's no definition of one of those.
So, well, we're talking about definitions, right? Are you looking at, you have it in definitions?
Yes, campgrounds, campsites.
Mine doesn't have that. Mine just has 17, mine just says campground, the next one's cemetery.
I thought maybe that was true, because you said the definition started on page 15.
Yeah.
Definition
But
started.
isn't
on
this
page
the
16.
one that,
I didn't copy it, John.
huh?
I didn't copy it. I don't know what happened to yours. Is yours
Mine has-
okay, Sue?
Yeah, mine has it.
Is yours okay? I don't,
Okay,
I will make sure I don't have any other copies copied up there.
you don't have any more?
We only have
Okay,
two
so
in the
this is-
closet.
Huh?
I only had 2 copies in the
No,
closet.
That's all right. I'll share with Dan.
Okay. I'll print you a new one tomorrow.
So the reason I wrote campgrounds and campsites, is campgrounds are planning for campsites. The gotcha on that is that it's the number of campsites. So once you hit 3, I think it's the number, then it becomes a campground. But it also, our definition also includes a number of people. So if you tell me you're going to put 12 people in those campsites, that becomes a campground,
Even if it's only one.
even if it's only one. Okay, but if you tell me you're gonna put 10 in those 2 campsites, then CEO approval.
So that would be a maximum, I assume.
Correct, yes.
Okay.
Exceed 10 individuals. And I'm fairly confident that comes from. From
The
state.
shoreline?
Yeah,
Oh, yeah, it does. come
It does.
directly from
Okay.
shore, which I think had its source from the state differences between the campsite and
campsite is, I think you might have mentioned plural. I read it as one on a property. One space for one group of people to camp. Versus a campground would be anything for more than one, or for more than 10 people at any one site.
But I think the state defines a campground as 3.
It might be the ordinance, doesn't it?
Okay. Well, we'll continue to move. Commercial use. We almost need to do this in concert with the table of use too, I think, as you kind of were doing. I mean, I guess what I wanted to talk a little bit about here today and make sure we're all on the same page and help Dan out is kind of what's the difference between a commercial use and industrial use. And then we also have uses that I would call commercial uses such as motels and restaurants, I believe. So, I mean, basically is, I guess, can we talk about what commercial use means? I mean, does it exclude uses that are specific, that are commercial in nature, that are specifically listed?
So commercial is in the table as a separate.
As is restaurants.
Yes, so the assumption is, and it does not clearly state what you're asking it to, is that if it is not already delineated in the table of use, then commercial use is a blanket that covers everything.
I agree with that.
Okay. Although it actually excludes home occupations
Correct.
and includes small scale solar energy systems, but okay, I'm fine. And then industrial is assembling, fabrication, finishing, manufacturing, packaging, which is also commercial, but that would fall under that same concept that you just talked about. And everybody's on that page.
So let's say you had an inn being proposed that was 15,000 square feet. What I would do is say, in that case, because we have a separate line item for inn, it doesn't qualify based on the number of square feet that they are allowed with the planning board permit. But if it was, a building that has a hairdresser, a counselor, and somebody else in it, and it's 15,000 square feet, that's going to be commercial and it's not allowed.
Okay. Yeah, yes, it would be allowed some places.
Something,
Yeah, right, in some districts. Okay,
just one.
you're right. All right. Dwelling unit, we talked a little bit about earlier. I don't know if we need to revisit that. We can, but. So this is a room or a group of rooms designed and equipped exclusively for use as a living quarters for one family, including provisions for living, cooking, and eating. So if we brought up on the subdivision, if you have 3 kitchens in a building, separate bedrooms, I would assume, or some sort of separation, then you have 3 dwelling units, even though it might be one building.
Correct. So if, let's say somebody's proposing, this is a good study question, somebody's proposing 4 yurts on the property, and they want to rent them out separately. It's sort of similar to something that's going on.
Yeah.
Okay.
No, it's not
Weirdly,
fine.
it's happening everywhere.
Yeah.
Let's do a different one.
No, that's fine.
Okay, 4 yurts. It could be a lot of things based on what's going on in those yurts. Are they renting them separately as like an Airbnb by the night? In which case, look at the definition of hotel motel, because it might actually fit that definition. Are they renting them by the week or the month? Maybe that's just a traditional single family house, depending what's inside each of them. Is there a bathroom that's right there, with the yurt, or is it something where they have to go to some main facility to use bathroom or cook? In which case, that's not a dwelling unit, each of them, right? So it could be a subdivision, depending on, again, what's in each of them. So there are a lot of layers.
So, and this is exactly the point of the exercise I wanted to get here from Dan, is that it's terribly unclear. A lot of interpretation.
Yeah.
And it's tough. It's hard to do. Okay. This is a big one, home occupation. Everybody in the world I think we got a lot of people who think they're doing a home occupation, but I'm not sure they actually fit under our definition. And that becomes an enforcement issue. So let's look at home occupation. An occupation or profession which is customarily conducted on or in a residential structure or property which is clearly incidental to and compatible with the residential use of the property and surrounding residence, which employs no more than 2 persons other than family members. That kind of gives it some substantive cutoff, which is helpful, I think. But other than that, that's clear as mud. And I'm not sure you could write it. I could write it as a definition, but can we talk a little bit about that? Because that becomes an issue from time to time. I remember people, is a hairdresser who has a room in her house and employs nobody, is that a home occupation? Well, I would too, but other people might not, because they say, well, that's not typically running the home. You typically go to another building, so I don't know. I just like to kick that around a little bit.
Yep, I think there are some keywords in here. So customarily conducted is one. So it says a occupation which is customarily conducted on or in a residential structure or property. There's certain types of businesses that we associate that people are commonly doing out of their home. Accounting, the hairdresser, and maybe, a seamstress, things like that. Real low impact stuff. There's not a lot of coming and going. They would have one appointment at a time if it's an accountant, and probably not that many appointments in a day. It's going to be one office that's small in a bigger building that they use for their home. So, if it's something more like an auto mechanic or auto body or fabrication, welding, real high impact stuff that you wouldn't typically associate as something somebody's going to do out of their home, then I think that customary piece of it matters.
What about auto repair?
I think it doesn't fit this definition, full stop. Boat repair, fiberglass work, stuff like that. If they're doing it in a barn in the backyard, maybe where it's fully enclosed in a structure, but if it's, they got vessels lined up out front that are all under production, I don't think that's a home occupation. And the other piece of this, though, that I think matters a lot is the incidental and compatible with piece of it. So if it's a building, home, 2,000 square foot home, and 1,000 square feet of it is dedicated to this commercial use, I don't think that's incidental. Even if it's 500 square feet, but they're getting, 20 vehicle trips a day. Let's say they're like a marijuana caregiver, and they got people coming and going. I think that can be not a home occupation anymore because it's not incidental or subordinate. So you're looking at the nature of it, you're looking at the frequency of, the use and the travel and the traffic. You're looking at, I'm sure you've got provisions about signage. I can't remember what they are, but.
Not a lot,
Yeah.
no.
Not
Okay.
one of those.
Yeah.
So if the
Actually, we don't
signage is,
anyway, do we?
That's shoreline zone. has.
Oh, yeah,
Yeah.
right.
okay, so the signage is unique to me. If they have a big old sign out front that, if you were passing on the street, you just look at it and think business, not residence. A lot of this is just smell test and it's subjective. It really is.
Kind of the duck theory.
Nope.
If it walks like a duck and quacks like a duck and looks like a duck.
Absolutely. But I look for that combination of like traffic, signage, impacts from the business, is it noisy, is it sneaky?
But a lot of people like to push this, which
They
is why I'm
absolutely-
kind of bringing it
And
up.
this happens a lot in towns that don't have a huge allowance for commercial use throughout the town. You think you're not allowing commercial use, but you actually are. People are just doing it on their quote residential properties.
And the way this is currently defined was done specifically to eliminate a category. And I don't even remember what they called it, but it was hobby. Something that normally is a hobby, and that could have included automobile repair. And we had a lot of commercial operations going on, and we didn't even know about it. So this was put in specifically to get a handle on. So there are still people that don't realize that they're.
Yeah, or quite frankly, I get a lot of questions. I wouldn't call it complaints, Pete, but a lot of questions about, well, how did you get to do that? I thought that was in a, and I'll, I don't know, talk to the code officer.
So my favorite amendment to this language to clarify is to say that if it's a use that requires planning board review, it can't be considered a home occupation. Or if it's a use that wouldn't be permitted in the district on its own, it can't be considered a home occupation.
Well, boy, that really restricts it.
I mean, it may or may not.
I
You
mean-
have to cross-reference with the table.
Yeah. So, okay. I just, again, I'm not gonna solve all of these things tonight, but just bringing up some of the things we typically run into and how difficult it is to move this.
Where are the definitions of non-conforming?
There's a whole section of
But
non-conforming.
no definitions?
It's in, I think it's actually in the
It's not in
non-conforming
there.
section. Yeah, it's on pages 2 and 3. Oh, I don't know if they changed. I got my old one here again, but
It's section 3, page 3. It starts now. There's a whole section on it. But you're right, it's
Not in definitions. It's kind of
not
odd.
in the definitions.
yeah, and I had that on my list on the E non-conformance, but we could almost spend an hour on that.
Ooh, this is, yeah, this is not, I mean, I don't know if there's different language in shoreline zoning, but this is not standard non-conforming kind of language. And we definitely want definitions.
Do we,
Yeah, because I think this goes.
do we,
This is actually not
Yeah.
great.
I know.
Yeah,
why don't we do this? I don't think we're gonna get through our agenda here. Why don't we, I do think we want to spend some time in our executive session. We picked out a few things. I also think we want to spend at least 20 seconds on the fire. If it's only to vote to send those documents to Kristen. So why don't we suspend this discussion from now, and I'm sorry, I screwed up. I thought the meeting was at 3, so I was here, sitting here at 3. And I have to leave at 5:45, and I'm sorry about that, but I think this has been a great discussion, and I actually wouldn't mind doing it again and finishing it, because I feel like now it's not to rush it. So why don't we suspend this for now? Let's all look at our calendars and maybe pick another date or to continue this, because I think it's worth it. Do you guys?
Yes.
Jeff?
Yes,
Sue, Dan?
Yeah, I've walked away on in a bit. Thank you.
I hope more than a bit. You have your calendar?
I am gonna look over yours.
Oh, okay. Can we do a similar thing, like 3 o'clock or 3:30? 3 o'clock.
I think normally 3 o'clock is a conflict. So
If it's not a regular thing, I can get out. It takes me 10 minutes. Well,
So it's-
probably.
Is 3:30 better for you?
It is, but, or 3:15, but I can,
Yeah, let's either do 3 or 3:30. People, I think, sometimes screw up when it's
Okay.
3:15 and today's the 17th. I'm just gonna throw this out there. Could anybody do the 24th?
What day is that?
Next
the
Wednesday?
Wednesday.
I can't.
Okay, that's easy. How about the 31st?
I can't.
How about the 30th?
I can do the 30th.
Yeah, Kristen,
It should be okay.
that work for you? Tuesday? Thursday?
You want 3 or
Okay.
3:30?
Well, I don't want to impose on you, but
I can, it's fine.
3 would work?
Yeah.
Okay, let's do that. So we're talking the 30th is 3. So now, is there a motion to go into executive session to?
You want to do C out of order?
Sure, just so we don't forget it.
I'd make a motion that we refer the draft purchase and sales agreement to the attorney for
Lease purchase.
lease purchase.
And can we say related material, because I'd like to also have her look at that performance bond if we're gonna give them.
And related material.
What we're doing here is town meeting gave us authorization to spend $850,000 and some change to buy 2 fire trucks. And we've had a proposal from we've selected the vendor, we've signed a purchase agreement with them. And we've had a proposal through them to finance it using a lease purchase arrangement. We own it at the end, they're fairly typical. So I guess we'd like you to look at that boilerplate document, and also we get a fairly substantial discount if we, and this has to happen fairly quickly, hopefully maybe by Tuesday, if we put down a deposit with the truck company. And they claim, they allege, they state that they will provide a performance bond, which I don't believe we have a copy of. But I will work to try to get you, Terry, or someone, those documents.
And we have something detailing what that deposit guarantees and refundability and whatnot.
No, I don't think we have much.
So they basically want a deposit before we have a lease.
No, they'll give us a fairly hefty discount if we put down a deposit. They're not requiring it.
Okay.
And I can send you that, but it's fairly substantial, from what I remember. If we put down 100% of the purchase price, which I don't think we can, because we don't have that. Well, I suppose we could if we signed the lease agreement, which is another cost, it's 25,000. If we put down 15%, it's 12,500. But of course, that would have to be netted out against what we're not gonna earn for the next year with it having invested in the bank, which isn't a lot, but. So I'll go into some more detail with it. So is
I'll
there
get back to you for now, because I'll get this all by email, right?
is there a second to Jeff's
I
motion?
second that.
Further discussion? All in favor? Aye. Okay.
I
That'll
have
work.
I have a partner, Bonnie Martin, she's a pro at lease purchase, so I'll send it to her.
Yeah. Okay. And I did look at, I've done a lot of them in one in my old job, and they have the non-appropriation clause and stuff, so, okay. So is there a motion to enter executive session to discuss a legal matter with our attorney regarding his CEO enforcement action? I forget what this,
Pursuant to Title I, Section 406E.
pursuant to Title I, Section 406,
E.
E. I have that in my
So
folder. Yeah. So second,
I second that motion.
further discussion, all those in favor? And I think we'd like